All right. Hi, everyone, and welcome to Featured Pros Live. We're so happy you could join us today. For those who are new, this series is all about real-world litigation. We sit down with experienced trial lawyers to talk through how they actually prepare and present their cases with LitSuite. Just practical, everyday workflows from attorneys who are actively in the courtroom. I'm Hillary Haynes. I'm the Vice President of Enterprise Relationships. I work closely with law firms throughout the LitSuite evaluation and procurement process with a focus on driving for firm-wide adoption across litigation teams. And joining me is Andrea Burton, our Chief Customer Officer, who I'm sure most of you have met. Andrea leads customer success, education and training, and oversees enterprise onboarding. She also partners closely with our product team to ensure LitSuite continues to reflect how litigation really works in practice. And of course, we have Tara Cheever, our co-founder. Tara will be monitoring the chat and fielding questions throughout the session, so please don't hesitate to send those in. So we'll be sending out a recording of today's session tomorrow. You should receive that from Ryan. And let's go ahead and get started today. So today, we're really excited to be joined by Shahrad Milanfar. Shahrad is a trial attorney and the founder of his own firm, representing clients across California in cases involving catastrophic injury, products liability, civil rights, and elder abuse. He's known for a very trial-forward approach and for using visual storytelling to bring clarity to complex, high-stakes cases. Shahrad, thanks so much for being here today and taking the time to share your perspective.
Thanks for having me. I'm glad to be here.
Yeah, so could you just tell us a little bit about the story behind the picture that you have in your background today? What does that represent to you?
So that's a photo or a painting by an artist by the name of Max Ross. I'll turn a little bit so everybody can see it. And it's a representation of the Muhammad Ali famous quote, float like a butterfly and sting like a bee. And so it was something that, I enjoy boxing, and my dad was a big fan of Muhammad Ali. And so when I saw it, I thought, you know what, this is an amazing painting and I need to get it. And I have a companion piece that's in our other office that we have, but it's just a reminder of flexibility, and being nimble is something that's important in our work and how we represent clients and how we show up for them.
What a great metaphor and symbolism. So Shahrad, to get us started, I'd love for you to set the stage for everyone. Can you just give us a quick overview of your practice today and the types of cases you're typically working on?
Sure. So I used to do defense work for 20 years, and in 2020, I started this firm. And so we're basically a trial firm that focuses on catastrophic personal injury, elder abuse, police brutality, and product liability cases. So I did a lot of product liability work on the defense side, and that obviously translates very well into our practice. And then when we started this firm, we basically had an elder abuse case that we took to trial and got a great result for our client. So that kind of put us on a path of representing a lot of different clients in elder abuse cases as well. And those are really significantly gratifying because you're showing up for an elderly person who didn't have a voice in the situation, and some corporation decided that, hey, we'd rather make more money than to essentially put the resources into the facility that it needed to properly take care of this elderly person and others in that facility.
Yeah, and most of our customers and a lot of people that I talk to every day, they think of LitSuite as TrialPad. But let's talk about early case strategy and intake. So when you're getting into a case before depositions, before motions, before trial, what are you trying to understand first? What are you trying to see?
So obviously being able to see the big picture is important, and the human aspect of it is important. So a lot of times people think, oh, I'm going to use technology and that's going to win the day. Well, the technology only enhances the human part, in my opinion. So when I'm looking at a case, I want to know, do I like the person I'm representing? Are they going to be credible? And what is it that they're going to bring to the table? But the other piece of that is that there's tons of documents that we have to be aware of and to know what notations are in there and all that. So being able to be properly organized, to understand the documentation, but also use the technology that's available to properly tell that story in a visual way is something that's important. So we're gathering info that's practically needed to prove the case from a technical standpoint and legal standpoint, but also how do we use the human part of it, of telling this person's trauma and what they have to carry forward because of what happened to them in a way that's going to resonate with the juries. But also I look at myself as somebody whose job it is to persuade, and that means to persuade the opposing counsel and the adjusters that I'm facing. So if I can do that, then there may not need to be a trial. But if it doesn't convince them, I'm happy to go convince that, a jury that this is the right result for our clients.
Well, you're setting a great example, but do you think lawyers sometimes wait too long to start thinking visually? If so, what do you think the downside is to that?
I think if we're waiting too long to think about it that way, we're not looking at the persuasion piece of it when it relates to the opposing lawyers and the adjuster that I'm dealing with, right? Because at the end of the day, if I call myself a trial lawyer, a lot of times we hear, we'll see you in court. And that's great. I love being in trial. And selfishly, that's where I want to be. But I always tell the other side that if I'm standing in a courtroom and trying a case, it's because you've put me there. Mm-hmm. I will give you every opportunity to do the right thing to resolve the case. But if that doesn't work, then fine, we'll go try the case. So understanding the piece that the earlier you start putting the presentation, for lack of a better description, together and the story together, the better you're going to be at telling that story to the other side and eventually to a jury if it needs to be done. Because if we have that approach, it makes us much more proactive in getting the case set up for resolution and trial, really.
So let's talk about how the technology excuse me, I'm losing my voice, how the technology fits into the storytelling in a very practical way. You've seen a lot of trial technology over the years. You've been up against, defense teams, insurance carriers. What makes a tool actually earn a place in your workflow as opposed to feeling like a distraction?
It's something that enhances my ability to tell the story. And it enhances my ability to tell the story in a very seamless way. And I'll give you an example. Again, I don't have anything against trial techs. It's just that I'm not one that's very good about using a trial tech. And the reason is, if I'm standing in a courtroom giving an opening statement or doing a cross-examination or a closing or even a direct exam, for me to break up my flow and turn to a tech to say slide number 5 or exhibit number 20 is very much a distraction, and it breaks up the flow and my connection to the jury. One thing that technology such as TrialPad provides is my ability to seamlessly continue that cross or continue to put on my presentation without having to break up the flow, which is very important in persuasion, in my opinion.
And let's talk about how you got started with LitSuite. How did you learn how to use it? How long did it take? What was the learning curve like for some of the people on this call who have never even downloaded the apps, haven't gotten started yet?
So as I was one of the first people to create an MCLE class on how to use an iPad for your law practice. This was in 15 or 16 in California. And I actually had to fight with the state bar to give the credit because they didn't think it was important in terms of giving MCLE credit for that particular class. And I had to explain to them, hey, how do you expect lawyers to show up in court and effectively represent their clients if they don't know how to use the technology? And since then, if you go and look at the ABA model rules and the California rules of professional conduct, there is now a requirement for us to be competent in technology. So that was a huge part of it for me. And in 2014, I started using TrialPad and actually, ended up trying a case to verdict as a defense lawyer. And it was a phenomenal experience. both the judge and the jury gave us incredible feedback. I mean, I did a direct examination of an expert, and I was remotely connected to my Apple TV, and I was able to stand in a position in a courtroom where I never would have been able to do had I been tethered to a wire. Those are things that mattered, and it allowed me to really understand, oh my God, this tool has a phenomenal amount of power that can be deployed in the courtroom. And so I started studying it. And look, the reality of it is, with anything that we do, you have to put some time into it. Play around with the tool, download it, and play with it to see what it can do. And then you can customize it to your approach and your comfort level in order to get the most out of it.
So without sharing your screen or doing anything fancy, can you share with the audience how you would direct someone's attention to a specific part of a document, a clause, a photograph, what have you, and some of the annotation tools that you typically use?
Yeah, so I'll tell you a story. So we're in the middle of trial, and I'm basically representing a trucking company that essentially caused the collision. Now, plaintiff's counsel is crossing another defense expert of my co-defendant, who really was at fault in terms of setting up the conditions that caused this collision. And while he's crossing that person, I offered to put up the document that he needed to cross this witness. And while while he's questioning him, I realized that there was an entry in that document that allowed us to show that our client only had 2.6 seconds to respond to the conditions on that roadway, when the other defendant had 14 years to fix the dangerous conditions on that roadway. So as he's doing his cross, I highlighted and did a call out of that particular calculation that the expert for the other side had done. And the other attorney picked up on it and crossed them on it, which then was a major issue that the jurors picked up on. So I can literally put a document on the screen and put a laser pointer on it and show the jury what's going on without even having a laser pointer in my hand. And the jurors are looking, and all of a sudden it catches their attention that, hey, this guy can put his finger on his iPad and there's a laser pointer on the screen that we can see. We can do call outs. If there's a portion of the screen or the document that we want to show the jury, you can call that out, and then you can save that and then put it in a closing argument slide in PowerPoint or Keynote. You can highlight things. So there's so many things that you can do, or you can underline things with a pen that's available there. So when I'm looking at it, if I'm a lawyer who's only using pen and paper and I hand the witness this document, and then I'm trying to use Adobe or something like that, it's probably not as effective as if I have that document on the screen. And then once we make the annotations of it, we can actually mark it as an exhibit and put an exhibit tab on it. And I literally can email it to the clerk, and then she can add it in as part of the record. And those are things that blow the minds of the clerks, and the jurors, and allow us to be much more effective in our presentation, because the other people are fumbling with paper and binders while we're doing things on the fly. I mean, I've literally walked into courtrooms with cases that had 3,000 to 4,000 pages of documents, and the other side is dragging in 8 to 10 boxes, and I have my briefcase on my shoulder and I walk in with my iPad. That's it.
Yeah, I mean, it sounds like you're keeping these jurors hyper-focused on what's important, and keeping the jury as engaged as they would be, scrolling their phones.
Absolutely. I mean, this is something we talked about, offline, and that is, as human beings, think about how many times you pick up your phone during a day. Now, imagine being forced through a jury summons to come to court and sit there, and then you're told to put your phone away. So your brain now is not getting the dopamine hits that you're so used to with all these notifications and texts or whatever. And you're sitting there and your brain is essentially starved of that particular stimulus. Now, the other side comes in and they have butcher paper and they write things on it, which is fine. And then I show up or another lawyer shows up with the tools that we have available to us. And now the jurors are seeing things that are dynamic, documents that come to life because I can do call outs, I can do underline, I can cross witnesses in an effective way where they say, no, that's not what the document says. Boom, we put it up on the screen. And in 2 seconds, I can show the jury that what this person is saying is not the truth. Or, this is something that you guys did recently was the ability to sync video to transcripts. So one of the things I did in trial a couple months ago was the witness said something that was contradictory. In real time, I searched up and found the testimony and played the video instead of reading that testimony, crossing that witness and saying, that those were your words, right? This is what you said. And she had to agree because it was her, in real life on video, basically contradicting what she had just told the jury.
Yeah, thank you for bringing that up too, because, most of the time court reporters will charge $90 to $150 per hour to synchronize video or for creating clips. So in addition to the cost, it also is a lot of back and forth that you're no longer having to do with a third-party vendor. So,
well, if I can add one other thing, in my opinion, even more importantly, is that if I have clips that are already pre-done, I can't go and change those in real time. With TranscriptPad, if the clips are, or if the video is loaded on and I have it, I can literally create a clip in real time and cross the witness with it right there on the spot. And that's what the value is that it brings to the table, is that flexibility and the ability to adapt in a way that was not available previously.
Well, how are you prepping for depositions today versus how you were doing it in the past, knowing that you're going to be presenting evidence in this format?
So there's a lot of different things that you can do, but previously when I was prepping, and I had to review other deposition transcripts, you basically review deposition transcripts that are in their own silos, so to speak. Yeah. With TranscriptPad, I can load all of my depositions into that system and actually run a search across all 5 transcripts, or I've had 22 transcripts in one case that we took to trial, and you could literally do a search and find excerpts from them and then mark those excerpts into the same report. And we've been in trial where they basically contradicted something, and in real time we're able to basically cross-examine that person because we're able to call up the particular piece of testimony that is there, and we can prep for it ahead of time or do a search in real time if we have to in order to cross that witness.
So I have a question from the audience, and they're asking, how easy is it to synchronize video in TranscriptPad? Is it easy? Is it difficult? How much time does it take?
So the answer to that is that originally it wasn't easy. It's gotten easier, but it does take time. So you have to look at it. You have to have an iPad that has the capacity to, have those videos there, but also you got to give it time to synchronize it. And I mean, I'm not saying it takes 10 hours. It takes maybe, 10 minutes for the video to synchronize to the transcript. So you have to be patient. But again, with trial prep, you have to put in the work to get the result on the other end. And everybody likes to see that, oh my God, you got this amazing verdict. Well, yes, but there was a lot of prep work that went into it to achieve that result. So does it make your life a lot easier? Absolutely. Is it a 2-minute fix? No, it's not.
Thank you for that clarity. And we have some skepticism today, which I'm super excited about. The audience is asking now, what's the setup like when you're going to the courtroom? What equipment do you need to bring? Is it complicated? Is it simple? Do you need other people to help you get set up? How does that work?
So I typically set up everything on my own, but what I also do is if I'm going to a court, I will make sure that I let the judge know and ask the clerk for a time before we start trial to come in and see what technology is available in court. So I'll give you an example. We tried a case in a county that's not our home county, which is Contra Costa County in California, in Sonoma, and they don't have really very much in terms of equipment. So we had to come in and figure out, well, what do we need to do? We needed our projector in a certain spot. We needed to be able to connect to it. And in that case, we didn't need to have an Apple TV because where we were going to stand and sit, it was right where we needed to be and nothing needed to be done. I tried a case in Contra Costa County. They have phenomenal equipment. All you got to do is show up with your iPad and plug in, and the video shows up on counsel's table in front of the jurors and on public TV screens that are probably 50-inch TV screens that they have available. So again, you have to put in a little bit of time into it. And if you're expecting to just show up and, hit go, that's fine. You can hire people to come in and set that up for you. But ultimately, what I would encourage people to do is to spend a little bit of time getting familiar with the app. So once you're plugged in, you're ready to go and you have a game plan and practice with it. I mean, we practice our openings, we practice our closings. Why not integrate the technology? But what I always tell younger lawyers that I've trained in the past is the technology is not a security blanket. It's something that enhances your abilities naturally as a human being and as a storyteller. So if you take that approach and you don't see it as a burden, like, oh my God, I have to do one more thing here. Well, yeah, you like the result, right? People like getting, good verdicts for their clients. Why not think of this as a piece of it and, spend a little bit of time for the maximum gain on the back end?
That's very smart and good advice. And just for the audience to know, we actually do keep some questions to ask that I can send over to you. If you need, to send the courtroom questions, we have a list of those that I can send over. And, one thing that we like to ask on these calls is, have you ever been in a situation where the other side also had TrialPad? And what was that like?
Honestly, no.
Not yet?
Of the cases I've tried, there has not been a lawyer who's used TrialPad. And I, subscribe to a website that has all these recordings for trials. And I've only seen one lawyer use TrialPad in those recordings, and that's, to me, that's an interesting thing that I've seen. But what I always say is, fine, come without it and see what happens, right? Because I would much rather try a case against somebody who doesn't use TrialPad than I would with TrialPad. And, I always joke that, I'm kind of hesitant to tell people about this tool because selfishly, I want to keep it to myself. So that's my take on it.
Well, let's go into trial prep. So for you, what does a well-prepared case look like before the trial even starts? And are you collaborating with anyone else in your office? Do multiple people have our apps, like your paralegal or an associate? What does the workflow look like behind the scenes?
So what we typically do is look at our case in terms of how we want to tell the story. And we then take our exhibits and put them into an exhibit folder that then allows us to have those exhibits in order as they come in. So again, it's not a perfect approach because you have to be flexible and you have to change in terms of how that case comes in or witness availability and that sort of thing. But if we can then number our exhibits in a way that tells a story, then that helps us better understand the big picture and how we go about presenting that story to the jury. So the workflow really is, okay, we've taken all these depositions. What's the story? And what I typically do is, I have my colleagues tell me the story. I tell them the story. Then we, talk to people who are not lawyers about the story. We may, have focus groups and that sort of thing. So if we can basically set it up in a way where we are understanding what the pattern is that we want to create for the jurors, and again, primacy, recency, and effective storytelling, that allows us to set it up so that when I transfer those exhibits into TrialPad and I have them in my Keynote or PowerPoint, then that allows us to work across the different apps in order to set it up and to tell a story in a way that actually is going to resonate. And not only are they seeing it, but they're hearing it from us, and that hopefully makes it more sticky for them.
What does your workflow look like with your files, specifically how you're organizing yourself in Doc Review Pad, Transcript Pad, and TrialPad?
So what I try to do is to have it mirror what's sitting in our servers, right? So basically, we typically have a trial binder, and then in that trial binder, it has different categories of documents. So once you get into our trial exhibits binder, then that's going to mirror the other, where it sits in the other apps. So if we make a change in our main server, we want to make that same change in the other apps so that it's pretty much consistent across the board. And that way it reduces the potential for confusion for us if we're standing in the courtroom and I'm looking for a document and all of a sudden it's not there, which doesn't happen because of this approach.
All right. I thought I had something coming in from the audience, but it doesn't look like I do. Oh, yep, one just showed up. I have used TrialPad for 2 trials this year and love it. The part that I don't love is the separate transferring of files from our file management structure on Windows. Any tips for more easily syncing documents between a Windows-based firm file structure and iCloud?
So we're actually very similar in terms of how we have our files, and typically one, you want to have an iPad that has sufficient storage because I want those files in the local drive on my iPad, and that then prevents, or I should say, it mitigates the risk if the internet goes down or you're not connected to the internet sitting in the courtroom. You're not stuck waiting, for the internet connection to come back before you can access those files. Moving the files from the server to TrialPad, I found the easiest way to do it is through like Dropbox. That makes the Microsoft tool is not as friendly for whatever reason. But the better experience I've had is from Dropbox to have it and it syncs, and then you just say, save it in the local drive, and then it's there and ready to go. But again, it goes back to if you're looking for documents in binders and fumbling around in binders, and there's 3,800 pages of stuff, and I can pull that up in 2 seconds while you're looking for the binder. That work that I'm putting in ahead of time to set it up is well worth it. Again, I always look at convenience as, okay, is there short-term pain here for loading the documents into TrialPad? If it means I look like a superstar in the courtroom, yes, I will put in the extra 10 minutes or an hour to make sure that's done properly. So I don't really see it as an inconvenience. I see it as, okay, this is what the technology limitations are currently, and I'm going to utilize it so that on the back end, if I can, provide a better approach for the jurors to see, then I would be able to do that.
And yeah, so I mean, my advice to anyone who's listening is please encourage your team to schedule some one-on-one training with Andrea. She can help you optimize all of your workflows. So if you're not sure how it should look in-house at your law firm, she probably has some great ideas up her sleeve. Shahrad, could you please tell us what the difference is between defense work and plaintiff's work? I'm wondering what this question means, actually. Hold on one second. I'm not really sure what that question means. Okay. Let's go to some questions that I had for the audience. What's one habit that made the biggest difference in your practice?
Um, Probably annoying all my friends by asking them what they think about the story I'm going to tell in a particular case. I mean, obviously, without giving the specifics of the case, I always make sure that by the time I stand up in that courtroom, it's not the first time I'm doing that closing argument. That closing argument is done over and over again in my head, in my office, and in talking to other people, and making sure that I'm comfortable and not reading a direct or a cross or an opening or closing. And this is the one thing I've seen in some trials that have gotten publicized in the media, and you see these lawyers after a 6-week trial reading their closing arguments. And to me, I'm like, how did you live this for 6 weeks and not know what to say? So I'm a huge proponent of creating outlines for things, whether it's a direct or a cross or opening or closing, and then having lived that case for the entirety of its existence. That's how I know I'm going to come in and tell the story essentially effectively from my heart, as well as being able to utilize the technology to match up what I'm saying with the imagery that's available.
And, I think we have some junior associates on this call. What would you do differently had you, early on in your career than what you did do? Is there anything that you would change? In terms of the technology and the way that you practice, knowing that this technology is out there?
Well, I mean, when I was a younger associate, right, a lot of the technology wasn't available, but I always wanted to figure out different ways. And, one thing I would tell younger associates is to learn about persuasion as much as possible on your own time. Read the book, Thinking Fast and Slow. It's a book about behavioral economics. And it'll teach you what persuasion is and how people think. And constantly think about, all right, how am I thinking differently today than I was 5 years ago? Because all of those things are what matters in our practice. So in that context, the younger associates in this generation have an opportunity that's significant. Most of your bosses don't understand technology, don't know technology. And now the ABA model rules and the California rules of professional conduct are now requiring it. And how many of us have heard, well, I'm not a technology guy? Great. Be the technology person in your firm, learn about it. And once you do, then that gets your foot in the courtroom and say, hey, I can help you do this. Help them set it up, help them run the technology. And when you're there, you say, well, hey, can I take a witness? And eventually you'll get that opportunity because you're now a valued member of the team and are able to contribute something that the the named partners may not be able to do.
Is there anything that you can think of that trial lawyers tend to overanalyze?
I mean, I think it depends on the person, but I think it's really important for us to get out of our own silos, and that's one thing I've noticed with both defense and plaintiffs firms is there's a fixation on, okay, this is it, this is the only way to interpret the facts, when in reality, what I think or what the other opposing lawyer thinks is irrelevant. We need to not fixate on that and fixate on what is a jury going to do with this? And how is our 12 people looking at these facts going to look at them in a way that maybe I don't see or the opposing lawyer doesn't see? And if you do that, then you're getting out of your own silo and you're taking the blinders off and you're able to see the field in a way that others may not be able to see.
And you often wear the litigation hat, but when you're an educator and you're teaching at NEDA or you're giving a CLE or you're teaching at law schools, how do you approach this technology with them?
Same thing is, encouraging the students to experiment with it. A lot of these particular MCLE classes that, organizations have are about teaching basic concepts of, persuasion. And so this is why it's important for me to be able to talk to others about utilizing technology as part of it. So I am always encouraging them and telling them about your products, because I think it's important, and it's a unique set of products that are on the market that help enhance our approach. And for the most part, when I show people at the end of these classes, after they do their presentation, and then I show them some of this stuff on my iPad because we're in person, all of a sudden there's this awakening, like, oh my God, that would have been a lot more persuasive had I been able to do that call out.
But a lot of associates will say, this looks kind of intimidating. What would you say to them about that?
It's intimidating if you don't. Well, let me back up. I always try to approach my practice and my learning from a curiosity perspective. And anybody who says that they're at the top of the profession and they don't have anything else to learn is lying to themselves and to their clients. So yes, it can be intimidating, but there is nothing more intimidating than losing a case because you put in an effective approach to persuasion and to showing the story to the jury. So I'd rather be intimidated initially and even frustrated. Oh my God, I don't know how this works. This is ridiculous. Why? Da, da, da. And then, they go through training with your folks and they all of a sudden learn, oh wow, you can do this or you can do that. And all of a sudden, you've learned something that makes you 10 times more effective than your opposing lawyers. Then great, that's where we want to be. And nothing worth having is easy. So when we look at it, right, everybody, who looks at these verdicts, whether it's a defense verdict or a massive plaintiff's verdict, everybody wants to fixate on that moment when they don't realize like the amount of work that these lawyers put in to get to that. And yes, in order for us to be good at our jobs, we have to do certain things that maybe are not the easy path, because the easy path doesn't get you accomplishments. The easy path is just comfort and average. And frankly, I don't want to be average. I want to work hard so that I show up for my clients in a way that maybe other lawyers don't do.
That's great. Well, you've provided so much advice for the young associates, and you provided, the perception of this technology by a jury. But how have the judges' perception of the tech that you use in court and in hearings affect your case presentation and your ability to persuade?
I've had the opportunity to talk to some of the judges I tried my cases in front of, and their feedback has always been uniformly positive about the way we've done it, because it has two impacts on the jury. One is that it's entertaining to them, and two, it's persuasive. But why is it that it's those two things? Is because one, it shows them visually the story, and two, it makes sure that they don't waste their time. And what the judges and the jurors have told us about our presentations using iPad and the technology is that when you stood up, Mr. Milanfar, we knew that two things were going to happen. One, we were going to be entertained, and two, you were going to be efficient and not waste our time. And I've had a judge, the first time I used TrialPad in a direct exam of an expert in that trucking case I was telling you about, the court basically, after we were done, dismissed the jury for lunch, and the judge stayed on the bench and looked at me and said, that was a phenomenal presentation in terms of how you put that on. And a lot of it had to do with my expert and, how brilliant he was. But at the same time, the judge was acknowledging that technology incredibly enhanced the presentation for the jurors. And you are getting feedback from somebody who sees this all the time. And I've even had clerks and court reporters say to us, man, that was amazing the way you guys did that. And to me, these are folks who see this day in and day out. And if they're giving us that feedback, it's worth putting in the work to get that kind of feedback and result that we get.
That's amazing. Well, before we call time, I have one more question from the audience, and that is, how do you incorporate Keynote or PowerPoint, or do you even use either of those for opening and closing? Any tips on using those tools alongside TrialPad on the iPad?
Yes. So Keynote and PowerPoint are important because I put my outlines in there, but I also use them when I go into TrialPad. If I want to do a call out, if I want to do something that's from the documents that are in those exhibits, I can literally take a screenshot of it and put it in my PowerPoint and Keynote. So the visuals match up in terms of what's in PowerPoint and Keynote. And if you use an iPad, there's actually a really great way to switch back and forth between those two if you need to, instead of basically double clicking or somehow trying to swipe up to get to the next app. You can literally do a 4-finger swipe and it'll switch from one app to the other. And that's how I go back and forth between Keynote and TrialPad, or even TranscriptPad if I'm showing a deposition transcript or an excerpt, is an easy swipe back and forth. And that's a cool power tip that you can use.
Well, thank you so much for sharing your time and your perspective today. I think, what really shined through is this isn't just about the technology. It's really about clarity, preparation, telling the story in a way that people can understand. So to everyone who joined us live today, thank you so much for being here. We recorded the session. We'll be sending it out to you in the morning. If you have any follow-up questions, please feel free to send us an email. And next week, we'll be talking with attorney Nicole Snap Holloway, who provides aggressive legal representation to victims of nursing abuse and neglect and relies on LitSuite every step of the way. Thanks so much for joining. Take care.